So, good afternoon. Hello, everyone. My name is Cassandra, and I'm so happy that you could join us for Heart Gallery's monthly webinar, Texas Adoption Assistant. We're so thankful that you could join us today. We're very excited to have Josh Kroll, a project manager of the Adoption Subsidy Resource Center, a program of the Family Rising, with us today. Josh has extensive knowledge of federal and state laws and policies that he draws upon to answer thousands of inquiries from parents, workers, and administrators. He also has been the main staff person at Family Risings for over 20 years, answering adoption tax credit questions. So throughout the presentation, if you have any questions, please feel free to use the chat. I'll be monitoring them. If you have questions, just put them in the chat, and then either throughout the presentation or at the end of the presentation, we'll make sure that we get to them to those questions. But for now, just please help me welcome Josh. So thank you, Josh, for being here today.
Thank you. So yes, I've been with Families Rising for almost 28 years, all that time supporting our adoption subsidy program. Even though I live in Minnesota, I'm in Minneapolis right now. We track information about adoption assistance programs throughout the US and Canada. And I will do a real quick overview of the federal adoption tax credit at the end of this too, because that is another resource available to families that I don't want families to miss out on. So I'm going to get started, and I did put in there, and I'll do it again at the end in the chat, and it'll be on the slides, my email. I'll put in my phone number at the end too. If you have questions that are more personal you want to ask, you can reach out to me that way, or you just have more follow-up at some point in time. Doesn't have to be today. Obviously, I've been around for a while and plan to for quite a while. So let's get started. So just a little bit about our organization. Our mission, this is our mission statement, is to amplify those with lived experience, assist adoptive, foster, and kinship parents, educate child welfare professionals, and champion the well-beings of children and families. We do this by supporting adoptive, foster, and kinship parents and young people, educating child welfare professionals, and advocate that children and families have support. And that's always been sort of the key of our organization since it got incorporated in 1974. I just lost that. Okay, so today I'm going to cover special needs definition, benefits, how interstate works, whether you're adopting from another state or moving to another state and have an adoption assistance agreement, when does subsidy end, how it interacts with Social Security, how it interacts with other college or other welfare programs and college assistance, and then at the very end, I'll throw in the federal adoption tax credit. So, special needs definition. This is going to be a little complicated, but not too hard. And it seems weird because there are a lot of things that are not disabilities. But to qualify for adoption subsidy, the child must meet the special needs definition. And special needs also means hard to place. In federal law, it gives a laundry list of things, including disabilities, but also sibling groups, minorities, age, as reasons children might be hard to place and they're considered special needs. So when you hear me talk about special needs, it doesn't necessarily mean a child with a disability. Ironically, in 2015, we were having our conference in Long Beach, California, just before they were having the Special Olympics there. And it's like, you know, that was a great example. Like, people think of people with disabilities, but in the child welfare space and also for the adoption tax credit, it also means hard to place. At the federal level, there are three components that need to be met to be considered special needs. The child must have a judicial determination that the child cannot and should not be returned to the home of his or her parents. That is something that is done in the month the child is removed from the home by DFPS or whichever state, foster care, does the foster care agency. Everybody else uses different language. DFPS is solely Texas, uses those acronyms. So that is done, even if you're fostering to adopt the child and you want to learn about this program, that's being done as that child is coming into care and may be placed with you, even if you're the first placement. There's nothing you have to do with that. In all my years, I've only heard of two cases where it mattered, where that was done wrong, and it made the children ineligible for federal funding, but they still qualified for state funding. The federal funding is called Title 4E. The state funding is called Not 4E. Um, and we're not going to go into much details on that because these days, other than this mess up, all kids should be Title 4E for adoption, not for foster care, not necessarily for guardianship, but for adoption. They should be based on being adopted. I used to spend time on that because it mattered, and it shouldn't matter for new adoptions at this point. If you have previously adopted and you have non-4E, you have questions, give me a call. But I'm not going to go into that any further. The second one is that there are reasonable efforts have been made to place the child with appropriate adoptive parents without providing adoption assistance. There's exceptions that exist for foster parents with significant ties to the child or relatives who are adopting the child. The reason I include this language in here, if I'm like fostering a child becomes legally free and I want to adopt, they ask me, do you want to adopt? I fill out the paperwork and yes, I say yes, and I fill out the paperwork. They're, they may not even ask me, can you adopt this child without adoption assistance? But if I'm going through like the Heart Gallery, being matched with a child that I've not been fostering, they may ask that question. This isn't based on federal law. You can say no, and then they will talk to you about the adoption assistance. In fact, in federal policy, they say that if you were selected, like if there was a staffing, let's say there were three kids or three families interested in one kid, they did a staffing and said, based on the home studies and all this, we think, and the demographics and strengths of this family, that they're the best choice, that we say, yes, we want you to be the adoptive resource for this child. If you say you need adoption assistance, federal policy is very clear that they're not supposed to say, oh, go to your second best choice. As soon as they say yes, you're supposed to then talk about adoption assistance. I don't think it's anything people are coming up with these days. If you think it's going on, we can talk about it and try and figure it out. But I don't think it's happening. I definitely don't think it's happening in Texas. And then the last part is a child is determined to have special needs, and that makes it hard to place them without adoption assistance. I gave you sort of the laundry list. Each state gets to set what that is. And this is what it is in the state of Texas. The child is 6 years old or older. So any child that's 6 years old or older being adopted through DFPS, even if they have nothing going on, even if they're like Doogie Howser, you know, they're like so smart, they're in college already, they're going to be eligible for adoption assistance because they're 6 or older. A child who is 2 years old or older and a member of a racial or ethnic group that exit foster care at a slower pace than other racial or ethnic groups will also be eligible. It's most likely going to be Latino, Hispanic, and African American Black children or mixes. But I don't know specifically, but that's typically what it is. Also maybe Native, but they'll be able to tell you but that's for younger children who are of color who exit foster care at a slower rate. If the child is being adopted with a sibling or to join a sibling for whom the parents already adopted or have PMC or other sort of permanent living arrangement with the family, that child will be eligible. So let's say I adopt a child, I adopt a 7-year-old. Birth family has another child. Unfortunately, they're not able to care for the child as an infant comes into care. DFPS wants to keep the siblings together. They reach out to me. Normally, I'd be like, I don't really, you know, my finances are a little tight. I can't take another child. Well, guess what? Texas is phenomenal with this. Minnesota also does this. There are a couple other states, but it's not too many. They say if that child is joining a sibling that you already have in the home, they will be eligible. Even if they're like 1-year-old healthy, don't need anything else on here because they're joining the sibling that I already have as part of my family, they will qualify solely based on that. which is great. And obviously, if I'm adopting a sibling group of 2, 3, 4, 5, 6, 7, um, and I'm, all together, they will all qualify. If the child you're looking to adopt doesn't meet one of these first three, then we're looking at number 4. And the child only needs to meet one of these 5 different categories. And the 5th one is a little redundant with the 4th one, but the child has a verifiable physical, mental, or emotional disabling condition as established by an appropriately qualified professional through a diagnosis that addresses what the condition is and that the condition is disabling. I've done trainings like these for a long time, and I've met foster families that have been fostering longer than I've been doing this work. So there are times if you're experienced, you might see the troubling signs before you have a diagnosis, which is great, but it's not enough for DFPS to activate and say this child's eligible for adoption subsidy. They need a proper a professional with the right letters behind their name to identify the condition and that it's disabling. That can be, and here's the big thing. Sometimes people see this, even though I read it, physical, mental, or emotional. I just really want to stress, a lot of times people think disabilities, they're thinking the physical ones, is the child got, cerebral palsy, Down syndrome, spina bifida, things like that, but mental or behavioral. Some of the children that come into care have experienced trauma or neglect, and they may have mental health issues, they may have behavioral issues. Those also do qualify. So I just really want to stress that. The hard part is with this age 6 years or older, or the 2 years or older, one of the really big problems out there is that the 5 and under kids, unless it's really obvious, it can be difficult to get a diagnosis. A lot of times medical professionals will want to wait to make a diagnosis once they're school age. If it's not super obvious, obviously something like Down syndrome or cerebral palsy, that's super obvious, but autism, that, if the child's nonverbal at 3 or 4, you might be able to get that. But if they're a verbal autistic child, a high functioning verbal autistic child, you may not get that diagnosis until they're school age. So it's a challenge. Other states do, like my state of Minnesota as an example, in Texas does not do this, just make this clear, offer like a $0 agreement with Medicaid. And then if a diagnosis comes later on, then it's really easy to activate it. In Texas, if that was a situation, you adopted a child without adoption assistance and then later on discovered a disability, you could go back. They will deny you. You'll appeal it. You may or may not win, but I do know families who have won and be able to get adoption assistance after the fact. But I wish Texas did it a little more like Minnesota in that respect. The last one, which is a little sort of redundant with what I was just talking about with disabilities, child is determined by the Social Security Administration to be eligible for SSI, Supplemental Security Income. That usually is a very high level of disability threshold to qualify. So if the child qualifies for this, they definitely qualify for that. So that's special needs. Gonna move on. I'm not seeing any questions. I didn't really, oops, I did not update that percentage. Ignore that percentage on the first part. Sorry, I was drawing this from another state. Title 4E of the Social Security Act provides the federal reimbursement. It's probably in the mid 50%. So the rest comes from state dollars. So if a child qualifies for Title 4E, that subsidy you're getting is all paid by the state of Texas, but they get reimbursed part of it. And those dollars, that Title 4E dollars that they get, that gives them, there's some conditions that go with it. And there are a couple other things that can help with it. When it's state only funded, non-Title 4E, the state pays 100% of it. So it all comes out of Texas's budget. I get these calls sometimes. Someone will call me up and say, hey, Josh, I get my subsidy from Texas, but I heard there's a federal subsidy. How do I go apply for that? They're all administered by the states. There's not a second subsidy check you can get. It's either a state non-4E or a federal Title 4E. Both are administered by the state of Texas or whichever state it is. There's not a second check available out there. So, benefits. Um,
Sorry, Josh, there was a question that popped up on the
okay,
chat. Do survivors benefit affect these benefits?
I'm going to get to that. That's a great question, but I have a slide on that. And as I was telling Cassandra at the beginning, I've been doing this for so long. I know what people want to know, even sometimes before they know they need to know it. But I will definitely cover that. It's a little complicated, but I have a slide. So, all right. Um, benefits. So in Texas, the monthly payments, generally for probably 95 or more percent of the kids are based on the Texas Child Care Centered Care categories. The basic rate, if the child qualifies as basic, the maximum amount is 400. If they qualify as moderate, specialized, or intense, it's 545. Okay, that's the maximum, and that's locked in. I don't think I haven't heard from anybody recently, and I don't think it's been going on, but for a while, I want to say maybe like 2007 through 2010, families had to negotiate up to that rate. But I haven't heard from anybody needing help with negotiation in Texas. I think they're generally offering that rate because it is sadly lower than the foster care rates that those children are otherwise eligible for. There is more recently, Texas has added an enhanced rate. And what I've heard from the state office is there's maybe 20 of these a year. They have to be a much higher need. They have to be specialized or intense under the T3C. They have to have been legally free for adoption, their termination of parental rights for 2 years. And there are some other criteria. That is in the Texas Administrative Code 700.807. In these cases, if a child qualifies for this, they can negotiate up to the foster care rate the child received while in foster care. When I looked at the Texas Administrative Code, I did notice, and I mean it's totally how it is everywhere in this country, that they specify that if the child was through like a private foster care agency, sometimes the higher need kids are go through private foster care agencies, and the state reimburses. They pay administrative costs to the foster care agency for case management and all the work related to providing that service. That administrative cost is not part of what's negotiable. It's only the payment to the foster parents. That maximum rate is what can be negotiated and enhanced. If you had a child that may be eligible for enhanced or you think might be eligible, feel free to reach out to me and we can go over, the Texas Administrative Code on that. Like I said, it's not very many kids a year. I know someone who I knew personally had adopted probably in the last 10 years, was trying to go for it. And it's just like, it's unfortunate, but the child was not eligible for it. So that's the monthly payments. There's also Medicaid. There's reimbursement of non-recurring adoption expenses. My understanding for Texas, and Texas not alone in this, I want to say Florida and Indiana operate the same way too, for sure, probably more, but you have to get your own attorney and they all magically cost the cost of that reimbursement. So the state will basically reimburse the attorney that you have to get for this. So it's not help. Like for Minnesota, we don't have to get an attorney. In Minnesota, it's 2,000. I think it's 1,200 in Texas. I didn't put it in because I don't think you really see it. But like in Minnesota, I'm in Minneapolis. I have relatives up in Moorhead, or Fargo, North Dakota, Moorhead, Minnesota. That's a 3 hour drive. It's 200 miles. Probably seems nothing for you Texans, but actually probably 240. But 4 hour drive. I drive up there. Like if I was getting matched with some kids up in Moorhead, I could get reimbursed for like my travel expenses up there, um, including mileage, staying overnight, meals while I'm there. Those would be things that are reimbursable. Also, things like attorney fees, home study costs, court filing, birth certificate, fingerprints. It wouldn't help, and it's per child. It wouldn't help with things like I was planning 2 siblings and I fell in love with 3 siblings. I needed an extra bedroom set, dresser, bed, stuff like that. That's not something towards the legal process of adoption. Um, and one reason I mention this is in many states, it could be useful. So if you're Texas, you're looking at Texas Kids, but you look broader, like Adopt US Kids. We used to be a partner of Adopt US Kids. You might look outside of the states. That could help with travel costs potentially, going to another state and all that. So I just want to throw that out there just so you don't, just in case you end up being broader than just Texas. Um, Texas also has a college tuition waiver program. I'll go into more detail of that at the end. But Texas and Florida were the first 2 states to do it, and they have very good programs providing college tuition waiver for children adopted from the from the state foster care system. So those are the big benefits there. Um, when I do a different slide, if you ever see me do our more general one, I spend some time in negotiation. I don't think that's an issue here. And renegotiation is not possible. If I adopt a child at the basic rate of 400, later on the child gets some, let's say the child's 7 but relatively healthy, the child hits puberty, hormones hit, some mental illnesses start showing up that maybe were genetic, hereditary, I'm still locked at 400 even with the new diagnosis. Most states um, will allow you to ask for an increase at that point. Texas doesn't, North Carolina, Michigan, those states you're sort of locked in at the time. So I'm not doing anything on renegotiation either because it's not possible in Texas. But if you're looking at another state, it is possible in other states. This is not to bash Texas. It's just, I know there's the internet. People look all over the place and they might, or you might be like, I'm interested in adopting, and boom, I have a relative living in Indiana that's struggling, child's coming into care, and all of a sudden I'm dealing with Indiana, foster care system, and there's, how does adoption subsidy work there if that ends up being the case plan for that child? So I just want you to know that things can work differently other places. And if they do, guess what? Call me, and we'll talk about it. So, speaking of, great lead in, interstate adoption. When children are in a state's foster care system, the adoption subsidy comes from the placing state. So my example there, if I were to now adopt that relative out of Indiana, I have to look, what is their definition of special needs? They're the best in the nation right now. In law, all kids adopted out of foster care are eligible. It used to be 2 and older for all kids. It's now 0 and older for all kids. It's all kids, which is great. But what are their rates? And do you have to negotiate them? You used to, as of last July, you don't anymore. But they have a 4-tiered system that you look to. So things like that. And are there other benefits that can happen in that other state? Like Missouri, Vermont have child care assistance programs, but do they work outside of the state? Vermont for sure doesn't. I don't think Missouri does either. The way they're structured and how they provide it. Medicaid, though, needs to come from the adoptee state of residence. If I'm adopting a kid from Indiana and I live in Texas, that Hoosier, they call it Hoosier Care because a lot of states have cute names. That Hoosier Care card isn't going to do you a lick of good in Texas. You might have a provider here or there that's done the paperwork, but it's just not worth it generally for workers to do it. Like if you were like at the border, like if you were in El Paso, and you lived in New Mexico, like I could see that, you might have some crossover there, just because how close things are. But generally, um, you need the Medicaid to transfer, and the Medicaid will transfer almost all the time. If it's Title 4E, the Medicaid transfers to wherever you live or wherever you live, wherever the child is. Um, and if you are moving, this is the most important thing about all of this here. If you are moving, let's say you adopted a kid in Texas, you live in Texas, and now you've said, I just can't handle how hot it gets in the summer. I want to try what this cold stuff in Minnesota is. You move up to Minnesota, you don't apply for Medicaid when you get to Minnesota. You reach out to your adoption assistance specialist. You have regional ones. You reach out to them, say, hey, I'm moving to this new state. This is my new address. I need you to update the system. So this is my new address, because you need to let them know where you are. And by the way, can you send the paperwork from Austin all the way up to St. Paul so that Medicaid can get established? If you try to apply on your own, you're only giving yourself a headache you don't need. The proper process is to have the state send that paperwork. There's this thing called the Interstate Compact on Adoption and Medical Assistance, and that's how it gets transferred over. There's forms that they know. You don't, if you talk to just an average Medicaid person, they're not going to understand that children who receive adoption assistance qualify for Medicaid on that. They're going to start saying, how much do you make? And all this other stuff. Don't do that. So, most states will provide Medicaid so if it's Title 4E, it will transfer to any other state, no problem. And these days, for new adoptions, that will be the case. People who adopted prior to that might have a child with a non-4E adoption subsidy, and it's going to depend on the COBRA reciprocity in the receiving state, the new state of residence. And we have this list of states that will where the problems show up. So Illinois, New Mexico, and Nevada do not provide Medicaid to children adopted from any other state who only receives a non-4E subsidy, adoption subsidy. Okay. So if you're in Texas, you're now passing, you decide, I'm going to move into New Mexico for whatever reason. Lovely, both lovely states. But you move to New Mexico, if it's non-4E, you will not get the Medicaid provided in New Mexico. But if it's 4E, you will. Same for Illinois and Nevada. Now, Iowa and New York used to be like that. And when they switched, and later on Pennsylvania joined them, where they started providing what they call COBRA reciprocity for non-4E adoption subsidies, they said, hey, we're going to do this for any state, but those that don't do it for our kids. So Iowa, New York, and Pennsylvania will provide Medicaid to children adopted from any state with a non-4E subsidy, unless it's the kids who get their subsidy from Illinois, New Mexico, or Nevada. So this is a really weird thing. Let's say you live in El Paso, you adopt a kid from New Mexico with a non-4E subsidy. Texas is great. Texas says, yep, we'll give you Medicaid, no problem. We're like that. And then you later on move to Pennsylvania. Pennsylvania is like, oh, wait a minute. This is the subsidies from New Mexico. And it's non-4E. We are not giving you that Medicaid. I can't fix that. That's a state level issue. The good news is Hawaii used to be on this list. New Hampshire, DC. I mean, slow progress, but it's happening. Sadly, with potential cuts to Medicaid coming down with the recent giant bill in Congress, I'm guessing these states aren't going to be changing their rules anytime soon. But if you're in this situation 3 years from now, you're like, I don't even remember the states, give me a call. I'll know how to look at the list, because they do get updated. Hawaii, I think, has been in the last 3 years where they got off these lists. So that's interstate adoption. Anything? Nope. All right. When does subsidy end? How am I doing on time? I'm doing good. So the agreements are through the child's 18th birthday, and the Medicaid coverage that comes with the adoption assistance will end when the subsidy ends. At that point, you can have an adult and have them apply for Medicaid on their own based on their situation. But it's really tough and really unfortunate because, you might be looking at trying to get the kid to college, which in your state is better than most, because of the tuition waiver. But losing that, you're like, well, can I add the child to my employer now? It's just like a headache you don't really need as you're trying to launch your young adult into adulthood, losing that benefit. Like my girlfriend, I started dating her when her kids were 18 and 20, and it was after the Obamacare passed, Affordable Care Act, and she was able to keep them on her work insurance until 25 or 26, which was great. But you if you rely on the Medicaid and then this ends, then you're like, I mean, it's a life change. Even if it's not during open enrollment, you go to your HR and say, hey, I need to, we had a life change. This child's lost their Medicaid. We need to add them. But then how much does that cost? There's a reason Medicaid is so crucial. That and the fact that it usually provides better services around behavioral and mental illness and things like that. Now, youth adopted at age 16 or older and prior to their 18th birthday can get adoption subsidy and the Medicaid extended to age 21 if they meet one of these requirements after age 18. And they have to maintain this. If they stops, and they have to meet one of them, and they can change which one it is, then if they don't meet any of them at some point, then it will end even if it's not 21 yet. So still in high school or an equivalent program, regularly attending a higher education program, including vocational and technical schools, but also colleges and universities and things like that. Active in a program that gives employment skills. Some children, if they have intellectual disability or emotional or behavior, may struggle to work independently, and they really need a jobs program to help them get the skills to be able to have a job in the future. That would qualify. Working 80 hours a month also qualifies. Or if they have a medical condition, that can work if they don't meet any of the other 4 criteria. So just one of those 5. But that's great. It'd be nice. The state of Texas, some other states do extensions if children have a disability that warrants continuation up to 21. Texas has never been that way. The closest state, I think, either sides of the Gulf is Florida, both because how they deal with the over 18 and also the tuition waiver. I think of the 2 states as very common in my eye, just in terms of their programs. They also don't do an extension other than just like this. If my slide for Florida would look exactly like this. So, but other states, a lot of states will do a continuation for disability, and some states will do it for kids still in high school. And when they do that, sometimes it's with their own money. They convert the 4E kids to the non-4E, and that's great, but it costs money. But they, for whatever reason, the states have decided that. Subsidy can end before the age of 18 if you are no longer legally responsible or financially supporting the child. In federal policy, it says you're no longer legally responsible if your parental rights are terminated, the child enlists in the militaries, marries, or is an emancipated minor. The state may determine you are still financially responsible if you're paying for therapy, gifts, toiletries, school supplies, clothes, things like that. Sometimes children need to re-enter foster care or they're out of the home to get services. The most frequent one is residential treatment facilities, therapeutic residential treatment facilities. And if you are receiving Title IV adoption assistance, and I don't think Texas would do this anyways, but if you're still financially supporting the child and legally responsible for the child, they might pursue child support for you, which you don't want, but they might. A lot of states do. But they can't reduce or suspend your subsidy without your agreement. Some try to act like it, Like in Kentucky, if it's non-4E and the kid's out of the home for 30 days, they will suspend it, but that's their money. I can't protect it with federal law. Um, so, and that money can be used to pay for the child support. The hard part is, I mean, 400 or 545 isn't enough to raise a child anyways, and it's usually more expensive when the children are out of the home than within the home. Um, but if you ever run into that situation, please feel free to call me and we can talk about it. It's sometimes it's just it can be a safety issue for the child to not be in the home. I mean, I've talked so many families over the years, and you can run into situations, and this is not to scare people off, but you can run into situations where it's like, well, if the child doesn't get into a facility, they're danger to the other children in the home, and then you'll charge me with neglect. I mean, it's just like it can be a really difficult situation. Um, so I told you I had a slide on this, and I'm doing good. Um, so I'm going to spend a little time on here. So when I first dealt with this like 20 years ago, I was pretty clueless. A lot of the stuff I've learned is stuff that families that I'm helping need to know. So I've learned a lot of stuff over time, and this is why I have a slide on this, is because I want people to know this. So if a child receives SSI, supplemental security income, that is based on the child having a disability. That would be like Down syndrome, cerebral palsy, spina bifida, other things. I know I've known some other ones, but those are ones I think the people might know. When they're in the foster care system, they're in the legal custody of the state. There's no family income attributed to them. Once I adopt them, they may qualify for SSI if my income and assets are low enough. But more often than not, it might go away. If it goes away, um, um, you don't, it's useless. Um, so the first thing I'm going to say on the SSI thing, if you're ever offered subsidy or a social security benefit, you always want to take the subsidy because that's a contract between you and the state, and it should go to at least age 18, possibly 21 if it's a kid adopted at an older age. Um, that's a contract. The Medicaid will be with it. Um, you want to do that. Let's say I'm a grandparent that is retired. Okay. If that child, well, that's not a great, let's say I'm a grandparent, just really low income, and the child can still get SSI benefits once I'm adopted. What will likely happen, and I've been trying to figure out the answer to this, and I've never succeeded in getting a clear answer. What will likely happen is it will be reduced dollar for dollar based on the adoption subsidy that is received. I think last year or this year was 941 for SSI as the maximum before, if you had no income reducing the benefit. If I got 541, I would get that, what, 396 from SSI and 545 from DFPS. And I could do that. But if my income brought it below the 545, I'd get nothing from SSI. Now, when that child turns 18, if the subsidy is going to end, I'm going to want to apply and get that SSI reinstated if the child still has a severe, significant disability that's chronic long term. Now, that is different than what uh, the survivor's benefit question is. Oh, yeah, and Carmen, I'll address yours at the end. I'll address the Medicaid one at the end. So the survivor's benefits, if the child's birth parent passed away, DFPS is getting survivor's benefit. They could say, they don't have to, they could say, we'll give you become the representative payee. That's the term for you receiving the money for that child who's getting the benefits. You can get the representative payee. Let's say it's $700 a month. It's more than the adoption subsidy. So we're going to give you zero subsidy, but they should give you at least a zero subsidy with a Medicaid card. That I can't stop, but if I have a signed contract with DFPS, and let's say I'm in a two-parent household, and we're both the adoptive parents to the child, um, and my partner passes away, they die, and the child starts getting survivor's benefits off their record, they can, if it's Title 4E for sure, and I don't think they would if it's not 4E in Texas. Maryland will, Tennessee might, but Maryland definitely will. They can't just reduce it without your say so. You can add that dependent benefit. The same goes if you become disabled or become retired. And that also applies, let's say you're a grandparent that's already retired and you're getting your Social Security retirement checks and you now adopt your grandchild and you've signed that contract for 400 or 545, you then apply to Social Security and say, hey, I've now adopted this child. Are they eligible for any family or dependent benefits? They've changed the name. I don't know what's the right term to use these days. So I use both. Are they eligible for any benefits off my record? And if they say yes and they start paying you, you can tell DFPS, but you have that signed contract. That's the key thing. Once you sign that contract, that rate, they can't change without your agreement. And if you ever have a battle with that, that's when you call me. So I hope this answered your question on the survivor's benefits. So if it's pre-adoption benefit the child's getting from the birth parents, DFPS can use it to offer zero or lower subsidy than normal. They're not required to, but I can't stop them from doing it. But if it's a benefit that comes afterwards, including potentially survivor benefits off the birth parent dying after you adopted, once you have that signed contract, any extra benefits you get for that child, DFPS cannot change without your say so. So, particularly if it's Title 4, I'm quite certain I have not seen anything and never heard anything in my 28 years of Texas would do that for the non-4E kids. So, I hope that covered that. And I'll cover after the next two slides. Well, actually, I'll cover it after this slide, the question about the Medicaid benefits that Carmen asked. So this always pops up every now and then in many respects, but the IRS does not count adoption subsidy as income. They made a revenue ruling, which is basically what I've been told by a lawyer at the IRS, means that it's not law, but they defend it as if law. The next levels down are chief counsel advice and private letter rulings, which are clarifications on a specific case, but not the same level as revenue ruling. And in 1974, they said that adoption assistance is not an income, is not income that is reported to the IRS. One reason I'm gonna do a little sidebar on this, especially for anybody that's fostering. Sometimes I'm like, I should put this in taxes or here, but I'm gonna put it in here. Sometimes people talk to taxpayers who maybe know a lot of things, but not anything as focused as I do. I'm not a tax preparer, as focused as I do. And they will say things like, well, you can't claim the child unless you report the foster care payments or adoption subsidy income. And that's just not true. You can claim children as dependents. There's 5 tests: age, a relationship, age, residency, support, and joint test. Relationship, foster parents, adoptive parents qualify. Age, it's like 19 or 24 if they're a student. Residency, lived with you for more than half the year for newborns, more than half the year they're alive. For support tests, that's the tricky one. The child can't provide more than half their own support. Foster care payments explicitly in IRS publication 501 are listed as support provided by the state or agency, not by the family, by the child actually himself. And I have seen one letter go to a foster adopt agent or organization in New York that said adoption assistance should be treated the same way. And then the last one is I said joint. They can't be married and filing a joint return, which is probably not what we're talking about here, but it's always a fun one to end with. If you're running into problems with that, feel free to reach out to me on that. So circling back to this, the IRS does not count adoption subsidy as income. Some people think that, oh, that means no part of government ever counts subsidy as income. And that, unfortunately, is not how our government works. School lunches and food stamps both count 100% of subsidy and family income. End of story. Now, school lunches, those determinations are usually made once a year. They're made usually in the summer, and a lot of kids get adopted in National Adoption Month in November. They say in the guidance that they would like you to report and stop qualifying for that. You don't have to do that, but you can if you want and say my child's no longer eligible because they're adopted and they get this. Foster children are automatically eligible for school lunches. Food stamps, like I said, count 100% of subsidy. In the Code of Federal Regulations, they specifically say even if state tries to exclude some programs and what's counted as income, you cannot exclude things funded like adoption assistance from unearned income is what they call it. Section 8 housing only counts 480 per year per child of the subsidy and family income. So if I'm getting $400 a month for a child and I have two of them, so 800 a month, that's 9,600 for the year. Yeah, no, yeah, 9,600 for the year. I'm only counting 960 when I'm talking to the Section 8 housing people. Low income home energy assistance program is probably heat cooling assistance for you. It's heating assistance for us. It depends on what your state does. I don't know what Texas does. Anybody that needs that or uses that wants to know how it'll impact their LIHEAP, let me know and I'll try and figure it out. It's sometimes easy, sometimes it's not, but it's easier for me to try because I've done it before. FAFSA, free application for federal student aid, like Pell Grants, do not count subsidy and family income. Bankruptcy, Chapter 7 and 13. It says do not include, this is on line 10, maybe A, do not include benefits paid under the Social Security Act. Title 4, Part E, that federal money is under the Social Security Act. So if you're going for bankruptcy, you would not include subsidy if it's Title 4 refunded. But if it's non-4 refunded, to my reading, you do count it. So to the question about, I need to make this a little bigger, the Medicaid benefits. So I am weekly on calls with the Child Welfare League of America, who are tracking a bunch of things, and even they can't keep up, but they're working with other partners who are keeping up with other things. I have never seen anything in that bill that targeted the funding mechanism. There was talk, the percentage I mentioned earlier, the 65 was wrong. That percentage, there's talks about some changes to that. I didn't see that happen. And Medicaid definitely didn't get, this population didn't get disqualified for it. What you're more likely to see as an impact is if you may lose providers, you may lose facilities that provide Medicaid if less people in your state have health insurance. There are areas, particularly in rural areas, where they're really propped up by Medicaid insurance because so much of the population that uses their services get that. So it's not going to be a direct impact, but there can be a spill over to it. And then to your question, so child or children already receiving survivor benefits will not also be given subsidy. I would ask for the subsidy. Don't tell them they can don't give them the opportunity to say no. Tell them, make them come up with a reason to say no subsidy. And if they say, because they get the survivor's benefit that's higher than the subsidy we give you, you get this, but then ensure that you get a $0 agreement with the Medicaid for them. That's what I would for sure do in that situation. But I have seen families get, the child's already getting the benefit and get the full subsidy. I had a case in New Hampshire once where they weren't going to offer the subsidy because of the survivor's benefits. And I'm like, do you have to do that? Do you have a rule or a policy that requires you to do that? Because there's nothing at the federal level that says you have to do that. Is there something at the state level? And that actually got the person processing it to say, all right, we're giving them a subsidy. So my general role, especially knowing how low the subsidy is in Texas, is don't offer them the reason to say no ahead of time. If they come up with it, say, oh, why is that? and, just ask questions. But then, at the minimum you should have, if the child qualifies, a $0 agreement with the Medicaid. And part of that is so that you can qualify for the adoption tax credit too. Um, yeah. And Carmen, you can reach out to me directly if you want to talk about it further. So, um, all right. So how are we doing here? 9 minutes left. All right. College assistance. So Texas and Florida were the first two states to have a tuition waiver program, probably right around when I started working here back in 98. It has changed over time to be better, more ages, and just easier for the adopted youth to be able to utilize it. Currently, any child adopted from Texas DFPS with an adoption assistance agreement is eligible for the program. These waivers are for Texas state colleges or universities, not other states or private institutions. And that's the really hard part. The only state that it opens it up beyond the state schools of the state they're in is Connecticut. Everybody else does it. The worst is Kentucky, because let's say I live outside of Kentucky, the kid goes back to to Kentucky for the schooling. They're going to have to pay the difference between in-state and out-state tuition. The in-state amount is waived, but they still have to pay the difference, which is like, come on, this is a kid who was adopted from that the state had a responsibility for. Why are you playing them like that? That's just not fair or right. Um, the regional adoption assistance specialist staff do provide the documentation to give to the school. Those will be your contact points to get that documentation. I did have one case that made me so sad, where I talked with a young man who had been adopted. He was in year 2. He didn't know about the program in year 1. And apparently, I mean, I got him connected, but apparently the school wouldn't go back, and DFPS, I don't think, could help him with it, wouldn't go back and waive his first year things, even though he was eligible for a waiver. So make sure if you got a kiddo that's doing this, that you have it all in place before they start generating bills. I don't, maybe it's not like that anymore, but just in case it is, make sure the kids know so they're not hit with the bill that they shouldn't be. But yeah, like the most common one that I get, where it's a private institution is like a beauty school or something like that. Like, um, we have a big, I don't, you've probably heard of Aveda there, they got a big teaching school over here that I know someone that works there. Those aren't going to qualify, but you might want to say, well, if you're interested in this, are there any like community colleges that offer similar programs? Um, you know, look at it that way. The other thing I'll add to this is if you have a child that's adopted at age 13 or older, but in another, it is looking for a different, state or whatever, or you've relocated to another state and they don't want to go back to Texas, no resources there anymore for them other than the waiver program. Any kid 13 or older can apply for FAFSA as a independent student where they don't put in family income. And that's been around since 2008. And that's for all states. So if you adopt a kid in another state that doesn't have a tuition waiver program, that will work for the older kids too. So I'm going to do another slide after this, but and I'll put in the chat my when I'm done talking my contact info. I'm going to talk about the federal adoption tax credit. So and I'll be doing a webinar. There's some questions in place that we have, or some questions that we're seeking clarification on, but this is the quick bullet points so you don't miss out on this. For adoptions finalized in 2025, it's $17,280 per child. If you receive adoption assistance, that is proof that DFPS or whatever state you adopted from determined the child as special needs. As we covered earlier, that also means hard to place. They don't have to have a disability. If it's considered special needs, the family can claim the full amount of the credit, even if they had $0 in out-of-pocket expenses for the adoption. That's usually those two parts, bullet point 2 and 3, are usually the biggest problem families working with tax preparers or doing it themselves have. For 2025, this is in the big bill. It's partially refundable at 5,000. We're pretty sure per child. That's how I read the law. You have to, if you're married, you have to file jointly. You can't file separately in year one, and there's an income limit. At 259,150, it starts to phase out, and it fully phases out at 299,150. Year two, if you're normally filed marrying separately for whatever reason, you can go back to doing that. And any carry forward can be split between the two of you. You have 6 years to use the credit. That's the carry forward part. It's like a holiday, giant holiday meal. Do you have leftovers? That's a carry forward or leftovers. You do it until you use it up or they go bad. That's why I use the leftovers. And you don't have to hire someone special to file for this credit. Now, the uncertainty that we have is, for sure, we're pretty sure that it's per child. We're hoping that it will help. The refundable 5,000 will help people who adopted between 2020 and 2024 because they can carry forward into 2025. Like I've been working with a grandpa for years who adopted his two grandma or granddaughters in 2022. He doesn't normally file taxes. I wanted to get clarity and be able to go tell him, hey, you're going to be able to get 10,000 this year. And then the next question related to that is, let's say I adopt in 2025, I use up 5,000 refundable, I use up 3,000 non-refundable, that's 8,000. I have 9,280 for next year, 2026. Will I be able to use 5,000 refundable in year two or not? In 2010, when the tax credit was made fully refundable, they did say the carry forward, which helped families as far back as 05, was refundable. So we're hoping that they do that. I just don't know the answers yet, so I can't tell you with certainty. But I hope to know this fall, and we will be pushing information out everywhere we possibly can, so families have that information. And there's my contact information again.